Everything you think you know about your rights in Australia, you learned from an American, a US cop show, a US TikTok, a lawyer shouting, I plead the fifth. Almost none of it is true here. There's no Miranda. There's no Fifth Amendment. They didn't read me my rights has never once got anybody off. But here's the one that should stop you cold. The myth that costs innocent people the most. You believe a police officer has to tell you the truth. They don't. Here, an officer can look you in the eye and lie, legally, and the High Court has said that's fine. Picture the table, the notebook, the pen resting on a blank page, waiting for you to fill it. 5 myths tonight, everyone believed by good people who've done nothing wrong, everyone exactly what police are hoping you still believe. Let's take them apart. Start where these encounters actually start. Not with a crime, with a routine. It's late. Wipers going. A torch beam finds your window and taps twice. Somewhere on a clipboard or a phone, a notebook opens and a pen settles on a blank line. That pen isn't writing yet. It's waiting for you. The radio murmurs a plate number. The straw in your drink is still in its wrapper on the seat, and your hands know exactly where to go. 10 and 2, wallet out, license ready. Here's the problem you're carrying into that window. Your instincts about your rights were built in another country. Probable cause. Miranda. Pleading the fifth. You absorbed all of it, and none of it is Australian law. You'll reach for protections you don't have and skip the ones you do. And that gap is exactly where the pen starts to move. And these moments are not rare. In 2022 to 2023, through random breath tests alone, NSW police made contact with drivers 3,727,999 times. Nearly 4 million ordinary encounters, one state, 1 year. Everyone a blank line in a notebook. So here's the promise. 5 myths tonight, and by the end, each one comes with a single line that shuts it down. But myth number 1 changes how you'll see every police encounter for the rest of your life. Because it starts with a lie. Theirs. And it's legal. Before we go further, know what this is and what it isn't. This is plain English Australian law. Every section checked against the statutes and the High Court, every reference sitting in the description below. No war stories, no invented career, just the law as it's actually written so you can check it yourself. And this isn't anti-police. Officers do necessary work, and most of them are decent people doing a hard job. The rules we're about to walk through exist precisely because the power is real. And knowing the rules is not the same as resisting them. Here's the frame that matters. These aren't tricks. They're myths. Things good, honest people believe. You're not learning to fight police. You're learning to stop accidentally helping them build a file on an innocent person. And that innocent person might be you. Because that's the trap. Believing a myth feels like cooperating. It plays like being friendly, like having nothing to hide. But in the notebook, it reads as volunteering. And the notebook doesn't care which one you meant. It only records what you gave it. That's why these 5 spread the way they do. Not as a survival kit for criminals, but as a warning to the honest. Send this to the person in your life who talks to fill a silence. The one who'd explain and explain until there was nothing left to explain. Myth 1, the big one. The one almost nobody believes until they read the case. Start with what you must do. Because getting this right is what lets you do everything else safely. You do have to identify yourself in specific situations. Under the Law Enforcement Powers and Responsibilities Act, LEPRA. Section 11. If police reasonably suspect you can help investigate an indictable offence, they can require your name and address. Section 12 makes refusing without a reasonable excuse, an offence. Up to $220. Give a false name, and that's a separate offence again. Behind the wheel, it's firmer. Under the Road Transport Act 2013, Section 175, a driver must produce a licence and give name and address. You must stop for a random breath test and you must blow. That's your body complying, and your body has no right to silence at the roadside. And please hear this. There are no magic words. I'm a traveller, not a driver. I don't consent to being governed. That has failed in every Australian court it's ever been tried in. It's not law, it's a fine, and sometimes a charge. So this is the deal that keeps you safe. Comply with your body. Give your name, your address, your licence, your breath. Protect only your words. Get the must right, and the myths can't be turned against you, because everything police are really hoping for lives in what you're not required to do. Starting with the biggest lie of all, that they can't lie. Myth 1. If it were serious, they'd have to be straight with me. They can. In Australia, police may lawfully deceive you to draw out an admission. This isn't a loophole. The High Court has looked straight at it. In Tofilau versus the Queen, 2007 HCA 39, officers posed as members of a criminal gang to win confessions. And in one of those appeals, police even used a fabricated police report to draw the words out. The confession stood. In M versus the Queen, 2007 HCA 46, police secretly recorded a man after deliberately giving him only half the caution. Listen to how one judge, Justice Hayden, put it. Every day, police officers take advantage of the ignorance of the people they eventually prosecute. Now the limits, because this is where honesty cuts both ways. A lie can still sink a confession if it was oppressive or degrading, under Section 84 of the Evidence Act. If it made the confession unreliable, Section 85. If an officer told a knowing lie in formal questioning to trigger an admission, Section 138. If they never cautioned you after arrest, Section 139. And they can never impersonate your lawyer. So picture the pen. You hear, mate, we've already got you on camera. Just explain your side. It's a bluff, but you explain. And the explanation is the admission. The pen moves. Police can legally lie, so never explain. Silence can't be faked. Which leads straight to the myth that makes the lie work, that you have to answer it all. Myth 2. If an Australian police asks me a question, I have to answer. Or that's obstruction. You don't. Past identifying yourself in those specific situations, you can stay silent. And under Section 89 of the Evidence Act, that silence generally can't be used against you. Not as guilt, not as suspicion. There's one narrow exception, Section 89A, for serious indictable offences, and it only bites after a special caution with a lawyer actually present. That's nowhere near a roadside, nowhere near your doorstep. Here's what the myth hides. The questions don't feel like a trap because they sound like small talk. Where have you been tonight? That's not chat. That's a timeline in your voice. Whose car is this? That's a third person, named by you. Answer to seem friendly, and every friendly answer becomes something to test later for the smallest inconsistency. You can't be tripped up on an account you never gave. Say you left at 11. A camera somewhere says 11:20, and an honest slip of memory now reads like a lie you chose to tell. That's the whole game. Not catching you in a crime, catching you in a contradiction. So watch the pen. You feel the silence, the pub, the mate's place, the route you took, the time you left, and your whole evening is reconstructed in order and signed off by you for free. name and address, then nothing. That's not rude, that's the law. So they stop asking to hear, and they ask to look instead. And this is where Australians get their rights most wrong of all. Myth 3, the most American import of them all. No warrant, no search. False. And here it's the opposite of the United States. In New South Wales, police can search you under LEPRA Section 21 or your car under Section 36 with no warrant at all. What they need is reasonable suspicion. In R versus Rondo, 2001 NSWCCA 540, the court set the bar. A reasonable suspicion involves less than a reasonable belief, but more than a possibility. And there has to be some factual basis for it. It's a real limit. It's a much lower one than a warrant. And your phone is no longer the safe you think it is. Since the 1st of February 2023, a digital evidence access order under LEPRA Section 76AO can compel you to unlock it. Refuse without a reasonable excuse, and you're facing $11,000 and up to 5 years. And the law says outright that incriminating yourself is not a reasonable excuse. So here's the one thing that hands them a search they couldn't otherwise do. Your yes. That's why the ask comes so gently. Mind if I have a quick look? Saying no can't be used against you. Your refusal is not by itself grounds for anything. Watch the pen. Mind if I have a look? Yeah, no worries. And the search that had no legal footing a second ago is now completely lawful because you authorised it. No warrant needed here. So say it. I do not consent to this search. And if that's true on the road, surely your home is the one place you're safe. Half right. Myth 4. Police are at the door. I have to open up and let them in. No. They're allowed to walk up your path and knock. That's an implied licence, the same one the postie has, settled in Halliday versus Neville. But knocking isn't entering. Without a warrant, your consent, or a specific power, the moment an officer crosses your threshold, it's trespass. In Kuru versus New South Wales, 2008 HCA 26, police who stayed inside a flat after being told to leave were found to be trespassing, and it cost the state. Say the genuine exception plainly, because it matters. Domestic and family violence powers and real emergencies do let police come in. Those exist because behind some doors, someone needs them there right now. This isn't a script for those nights, and you'll know if it's one of them. But on an ordinary night, watch the pen. We'll just step inside and sort this out, yeah? You move back from the door to be polite. That step back is consent. Entry is now lawful, and everything they can see is in plain view and in the notebook. The doorway does the work if you let it. You don't argue through it. You ask one calm question through the gap. Your doorway is a line. Ask one thing. Do you have a warrant? So they can't take the truth from your mouth, your car, or your house without your help. Which is when people reach for the last myth, the American security blanket. Myth 5, the security blanket. They never read me my rights, so it all gets thrown out. There is no Miranda in Australia. Police must caution you once you're under arrest. That's section 139 of the Evidence Act. But if they don't, your case is not automatically dead. Whether that evidence stays out is a discretion. Section 138 makes a judge weigh how valuable the evidence is against how badly it was obtained, and then decide. The High Court settled this in Kadir versus the Queen, 2020 HCA1. Improperly obtained evidence is not automatically excluded. There's no American fruit of the poisonous tree here. One flaw doesn't poison the whole case. A judge balances. Sometimes the evidence stays in anyway. In America, the rights warning works like a switch. Miss it, and what follows can fall away on its own. Here it's one factor a judge weighs against everything else, and the weight is theirs, not yours. So watch what the myth does to you. You stay chatty at the scene, relaxed, because you're certain some technicality will rescue you later in a courtroom. And the chat, everything you said while you were sure it wouldn't count, becomes the case that no technicality ever touches. You didn't stay silent because you thought you didn't need to. No Miranda in Australia. They didn't read my rights won't save you. Silence will. That's 5 myths down. Now, the 2 mistakes that turn all 5 of them back on you, and the 2 people you must never become. So the notebook sits open and it gets offered 2 easy meals. Don't be either of them. The first is the over-explainer. He hasn't done a thing wrong and he cannot stop proving it. He offers the full itinerary. Alibis nobody asked for. The names of his mates, where they were, what time they left. He thinks innocence should be obvious, so he keeps talking until it is. And here's the cruelty of it. Innocence, over-explained, reads as nervousness. And nervousness, in that notebook, reads as something to look into. He talked himself from a witness into a person of interest. That argument wins in a courtroom months later, in front of a magistrate. It loses on the footpath tonight every time. You do not debate the officer. You decline calmly, and you win it where it's actually decided. Because the myths don't really hurt you on their own. They hurt you through these 2 reflexes. That argument wins in a courtroom months later, in front of a magistrate. It loses on the footpath tonight every time. You do not debate the officer. You decline calmly, and you win it where it's actually decided. Because the myths don't really hurt you on their own. They hurt you through these 2 reflexes, the urge to explain and the urge to argue. Kill both, and there's almost nothing left to write. There's a way to hold all 5 of these at once. One posture, one flat, calm line. And it's boring on purpose. Here's the whole posture, and it's almost dull. You identify yourself. You comply with every lawful direction, with your body, and you decline every question and every search with the same flat, polite words, every single time. Not louder, not cleverer. The same. The line is this. Officer, I'm staying silent, and I don't consent. Watch it hold. He leans in. Come on, just tell me where you're headed and we're done here. Say, officer, I'm staying silent and I don't consent. He tries the other door. If you've got nothing to hide, you won't mind me checking the boot. Same words, same tone. Officer, I'm staying silent and I don't consent. You don't escalate. You don't explain why. You're not making a stand. You're a person politely declining a survey. That's the whole delivery. The law does the work. Your only job is to be boring. Boring is forgettable, and forgettable is how encounters end. Then, when it's over, before you drive off, do your own paperwork. Under LEPRA section 202, an officer should give you their name, their place of duty, and the reason. Note all 3. Write down what happened while it's fresh tonight. Signed notes tonight beat a foggy memory at a hearing a year from now. And keep this number in your pocket. After a drug dog flags someone, the landmark 2006 New South Wales Ombudsman Review found nothing on about 3/4 of the people then searched. The machine is wrong most of the time. So are the myths. Put all 5 together and the notebook stays empty. Lift out of the interview room for a second because none of this is theory. In September 2025, the largest class action ever run against an Australian police force reached judgment. The New South Wales Supreme Court found a gross failure in the way police ran strip searches, a flagrant disregard for one woman's rights, and awarded the lead plaintiff $93,000. She's one of more than 3,000 people in that action. And the search that started it? A drug dog sniffed near her, then moved on. And thousands more searches from those years may now be unlawful too. The judge is still to decide how much the state pays for the rest. The phone unlock power, meanwhile, is barely 2 years old. It didn't exist the last time you thought hard about your rights. And this year, the whole country watched a clip. Police at a Sydney cafe stroll out to a running ute, pull the keys from the ignition, lock it, and go back to laughing at the window while the driver came out and searched his own pockets over a coffee. These aren't hypotheticals. They're this year. Myths survive on 4 quiet words. It won't happen to me. The news keeps saying otherwise, which is exactly why you memorize the 5 lines now. Calmly, tonight, and not in the half second you actually need them. You don't rise to the moment. You fall back on what you already knew. So here they are. One more time. 5 myths, 5 lines. Let's put it all together. 5 myths, 5 lines. Police can legally lie, so never explain. Name and address, then nothing. No warrant needed here. I do not consent to this search. Your doorway is a line. Do you have a warrant? And there's no Miranda. Silence is what saves you, not a technicality. Hold those 5, stay flat and polite, and you become the most boring stop of the officer's night. Every one of these, with the exact words for every state, is in the book Know Your Rights, linked below, waiting for the night you weren't expecting. One honest caution. This is general information, not legal advice. If your night has gone past a knock or a stop, the video ends and the lawyer begins, and legal aid exists in every state in this country. Use them. So subscribe, not for luck, but for the next knock, the next window, so nobody in your family gets caught believing a myth. And if an officer ever leans in and says, "I can smell alcohol," that's not a myth. That's a specific trap with its own single sentence. That video is on your screen now. Back to the table. The notebook closes on a blank page. The pen clicks shut and goes back in the pocket. The chair scrapes in. Nothing written. And you walk out.